Is that, oh, that's what you emailed me.
No, that's what he handed you.
Yeah, no, this is Ms. Giddens before the court in 23 CF 545. We have a plea agreement to be filed. I'm waiting for the state signature on that.
Thank you.
This is good misdemeanor this court. She will immediately on the approach.
Thank you. You may announce, please.
Yes, Your Honor. Ms. Giddens is going to be entering a plea of no contest to count 2, the information. In exchange, the state's agreed to dismiss count 1 of the information. She'll be adjudicated guilty, sentenced to credit for time served, standard court cost, PD fee. Ms. Giddens would ask for 24 months to pay those outstanding fees.
Is that the agreement for the state?
That's correct, Your Honor.
Very good. Ms. Giddens, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. Pull that mic down. Counsel. And Ms. Giddens, I see that you have signed the plea agreement and that has the same terms in it that your attorney just stated. First of all, did you read this plea agreement closely?
Yes, sir.
And did you go over it in detail with your attorney, make sure you had all your legal questions answered?
Yes, sir.
And you understand that by entering this, you're waiving some valuable legal rights. You believe that's in your best interest to do that?
Yes, sir.
And you had all your legal questions answered regarding this?
Yes, sir.
Okay. Based upon that testimony, the court will accept your no contest plea for count 2 in exchange for a dismissal by the state. For count 1, there'll be an adjudication of guilt, and you'll get credit for time served, fees and costs as contained in the plea agreement. You'll have 24 months to pay, and then it'll go to collections. Okay? Any questions?
Madam Clerk.
Yeah, I said, that's what I meant to say. If I didn't say that, did I miss that, counsel?
I thought you said it right, but I might also...
And Judge, I'm going to owe you a score sheet on this case.
Misdemeanor.
It's a misdemeanor, so you don't need one.
Thank you.
Very good. Thank you.
Thank you, Your Honor.
But don't
Your
ever
Honor.
mistake that if I do miss it, because I want to get it right. Counsel, I'm sorry.
Your Honor, if you wouldn't mind calling Mr. Hammett.
Hammett? Okay. Mr. Hammett? And then we'll have Mr. Hunter, I believe. Okay.
Your Honor, Mr. Hammett and I had the pleasure of speaking. We do have a tentative agreement. However, I do need to draft it up. And I think he also was hoping to come back and sign it next week. If we set this for next week's date.
That'd be fine. We'll come back on May 16th, and we'll come back in the morning, 9 a.m.
Thank you, Your Honor.
Okay? We'll go ahead and enter the not guilty plea, and then come back.
All right, Mr. Hunter.
Mr. Hunter? All right, Mr. Hunter, this is case number 2023 CF 450. So you do have a right to an attorney with these new charges.
I've tried to find out who my attorney is, and they said they didn't get my paperwork. So I went to the clerk and filled one out. I still haven't had any contact.
So what we'll do is we'll go ahead and appoint the public defender today, and then you say you have filled out the paperwork?
Yes, sir.
Okay.
I came down to the clerk to fill it out.
Okay.
And I apologize, I was in the wrong courtroom.
It's all right. It's a big courthouse. I'm glad you got here.
Can the state put the offer on the record just so that Mr. Hunter's aware?
Certainly. The offer is plea as charged, adjudicate guilty, credit for time served, because I think he has the 10 days to meet the statutory minimum, and then obtain a valid driver's license.
In what?
Obtain a valid driver's license.
Okay. So you've already filed, so I'm going to appoint the public
Yes,
defender, assuming he's still got to get it approved.
I didn't see an application on the clerk's website either. Madam Clerk, see one?
I can fill out another one on the way out
Okay.
if you'd like.
That'd be great.
And just so Mr. Hunter's aware that basically
Okay.
the state's offer is time served and court costs. That's what they're asking.
Okay. All right. The capias,
Court will withdraw the case.
thank you very much.
I appreciate you reminding me. 'Cause
Yes, no
one-
problem.
Important. So we'll go ahead and enter a not guilty plea. Let's see. Not guilty plea, and we'll come back, why don't we come back next week, May 16th at 9 a.m. And then, is that too short a time frame for you to be able to go over? He's not in jail, so we can.
Yeah, sure. It may be too quick.
You want to do it a month out?
I think June 12th is when he's scheduled for, Your Honor.
Okay.
That'll give me time to meet with Mr. Hunter, because it sounds like, I mean, it's a very reasonable offer given the circumstances. So it may just be a conversation you have to discuss that in a little more detail.
Just make sure and get some information from your attorney so you can follow up and make an
Yes, sir.
appointment. Okay? So we're entering, what we're doing today is we're entering a not guilty plea in your behalf. We'll come back on June 12th at 9 a.m.
Okay.
And in the meantime, fill out the paperwork and communicate with your attorney.
Thank you, sir.
Okay? Thank you.
I believe Mr. King is left, Judge.
You still have Mr. King? Okay.
All right, so Mr. King, come on up.
Judge, Mr. King is number 3 on the afternoon docket.
There we go. Gotcha. Sorry.
Your
Would you
Honor,
just announce the case and tell us where we're at?
certainly, Your Honor. This is Dramaris King, case number 2023 CF 460. Mr. King and I had the pleasure of speaking while the court was in recess. The offer is an adjudication of guilt, 3 years probation, during which he would be subject to random urinary analysis, and he would have to obtain a substance abuse eval and any recommended treatment. Mr. King has requested that we move the case, and I believe he's also asking for a lawyer so he can consider the
So
offer.
what we'll do is I'll go ahead and appoint the public defender. You'll have to still fill out the form and pass that down to the clerk's office and maybe on the way out. And we'll go ahead and enter a not guilty plea. And we'll come back on 6/12, so on June 12th at 9 a.m. for the pretrial. In the meantime, you can meet with your attorney, see this, the offer will stay on the table. You can figure out whether it's in your best interest to try and do that or proceed to a hearing or whatever. Okay?
Yes, sir. And, Your Honor, I don't believe I have any other cases before the court. May I be excused?
You may.
Thank you for your time.
Thank you.
Sorry.
Welcome to this division, officially.
I appreciate it.
And Your Honor, I did see, for the motion hearings this afternoon, I did see Ms. Dudley was out in the hall with her client, and Mr. Medina's client, I'm not sure is here yet, so I'm just gonna hang out until my cases are ready.
Well,
I
if
don't-
Ms. Dudley is not ready to go, we'll go ahead and do the sentencing first.
I have Anthony Griffin, is that?
That should have been continued. this morning. I think that was with,
Which one?
Anthony Griffin.
You don't have one?
Whose case is that?
It was Mr. Morrow's, Your Honor. And I don't know if it was Mr. Rogers or Mr. Moscow.
Is that it for you?
We'll continue it till, what does it say? 6:20.
And that's all I have before the court as well.
Okay, very good, thank you.
I'll just wait.
Okay, let's go ahead and do Dunham. Shaw, Dell.
And Your Honor, as counsel gets settled, if I may inquire of the court, does the court need a printed out hard copy of the score sheet? We had we attached it to our sentencing recommendation memo, but do you need a copy for today?
I mean, I've got what you provided to me, so I've already got that.
I just want to make sure, 'cause sometimes the judges would like a hard copy that they can sign.
No,
Thank you,
I've got, I mean, I printed all, of them. It should be the same one.
Yes, it is, Judge. Thank you.
Right, so you want a hard copy in order for me to sign it, make sure and pass that. Is that what you're asking about?
Yes, Your Honor. I just wanted to be sure that that was available if you needed it.
Yes.
And I'll show it to Mr. Shaw before I bring it up. Mr. Shaw, this is what I provided you previously, if you just want to double check it.
Are we ready to proceed?
The state is, Your Honor. If I may approach with this?
Amen.
The state for today, Your Honor. Probation will ask.
Thank you. The defense is in agreement with regards to the score sheet?
Yes, Your Honor.
Mr. Shaw, you may proceed, sir.
Thank you, Judge.
You go ahead and announce the case to me.
Yes, Your Honor. Tim Shaw and Jay Patel for Bradley Dunham, 21 CF 1573, Your Honor. At this time, Judge, we're before the court for sentencing, having entered a plea to the court on January 10th, 2023. The plea was as charged. A PSI and a PDR were ordered and filed with the court previously. Bradley Dunham is currently 19 years old. He was 17 years old at the time of his arrest. The information charges offenses beginning November 22nd, 2020 through April 8th of 2021 when he was 16 and 17 years old. We're asking the court to find and to depart from the sentencing guidelines on the following bases. Number one, 921.00262D, and I'll just read that to the court, that the defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction or for a physical disability, and the defendant is amenable to treatment. Also 921.00262K, which is at the time of the offense, the defendant was too young to appreciate the consequences of the offense. And 921.00262L, that the defendant is to be sentenced as a youthful offender. In support of these requested departures for the court to find these mitigating factors, we would call several witnesses. As we do so, Judge, we believe the court will see that Mr. Dunham's youth, his mental disorder, and his immaturity all form the bases for these mitigating factors. Judge, the first witness that we would call is Deborah Jolly.
Clerk, please swear the witness. Please be seated. Pull that mic right up to you and pull it over to you. Just pull it down. There you go. Thank you.
You're welcome.
Mr. Shaw, you may proceed.
State your full name, please, ma'am.
Hi, my name is Deborah Ann Jolly,
And Ms. Jolly, how old are you?
34 going on 35.
Okay. And where do you currently reside?
New York, New York.
And what is your relationship to Bradley Dunham?
He's my brother.
Okay. And I have a hard time hearing. If you could get a little closer or pull that mic a little closer to you.
Sure. Is this better?
Yeah. And Bradley's your brother?
That's correct.
All right. Are you employed, ma'am?
Yes.
Where are you employed?
I work at Société Générale. It's a French investment bank.
Okay. And you said that's in New York City?
That's correct.
All right. How old were you when Bradley was born?
15.
Okay. And did y'all have the traditional home life sibling relationship?
Unfortunately not. When I was 15, I moved to live with my dad in North Carolina, so I saw Bradley every summer, every other holiday, and talked on the phone.
Okay. And as he got older, went through elementary school and up into his early teens, did you talk to him regularly on the phone?
As much as I could. When we had our more frequent conversations is when I was in college, so.
Okay. In your interactions with your brother, as he was in elementary school and on to middle school and high school, did you recognize any problems with his development?
Not at first. When he was a kid, he was a normal, happy kid. But as he grew into adolescence, I noticed things that were different between us. I always had a best friend growing up. I always had sleepovers at my house. Bradley never really had a best friend. Any friends that I knew of in person, I never met or saw pictures of. Every time he mentioned connecting with someone later on was through the internet.
Okay.
Who was what?
It was through the internet, so no in-person connection.
Did he ever have any girlfriends or anything of that nature?
No.
Okay. Are you familiar with his grades, how he was doing in school?
Not well. So our phone conversations in my early 20s were about his homework. My mom asked for us to connect to help and go over like math and English with him as best as I could from a distance.
Are you aware of him ever being held back in school?
Yeah, I believe they held him back for 1 year. He wasn't doing well in school. His grades were slipping in to ensure that he had the best opportunity possible. They held him back for another year.
Okay. Do you know how he did for the second time?
Not really that well.
Okay. And did he seem to, well, when he was held back, did he seem to get along better with that age group than the age group that he should have been with?
Yes, I mean, he gets along with most everyone. He's never had someone say anything bad about him. I've never heard anything bad about my brother until I guess recently, but it seemed like the age group that he was in, he was always influenced by them, so he was always younger than what his actual age would be.
How would you describe his maturity level?
A few years younger than what it should be. Again, his peers were always a year to 2 years younger, so it was always hard to really connect with someone who's already 15 years, apart, to think then again his maturity is a year to 2 years younger than that.
Is there anything else you'd like to tell the court prior to the judge passing sentence on Bradley?
I know Bradley is a good person, and with the opportunities that this court and the community can provide to him, I believe he will continue to be a good person and have the opportunity to be a successful person within our community, again, with the support of the court and his doctor.
Okay. Thank you, Judge. I don't have any further questions.
Thank you.
No other questions, Ms. Jolly. Thank you, ma'am.
Thank you.
You may be excused. Is she excused?
Yes, Your Honor.
Okay, thank you.
Brian Dunham.
Swear the witness, please. Please be seated. Mr. Shaw.
Thank you, Judge. State your full name, please, sir.
Can you hear me? Okay. Oh,
State your full name.
Brian Edward Dunham.
And how old are you, Mr. Dunham?
50, I forgot, 50, 58? 58. Sorry.
And where do you live?
115 3rd Avenue, Southwest, Florida, Fort Walton Beach, Florida.
And how long have you lived there?
About over 20 years.
Who lives there with you?
Andrea Jolly, Bradley Dunham, and myself.
And Andrea Jolly is who to Bradley?
His mother.
And you said Bradley still lives with you?
Yes.
Lived with you his whole life?
Yes.
If you could, describe to me Bradley's childhood and how he progressed growing up.
Well, he's been a good kid. I mean, I haven't had too much trouble with him, but he is awful forgetful. We held him back in 3rd grade so he can get a little bit easier to go to 4th grade. They told us he needed to know his stuff before 4th grade, so we held him back, but his grades were about the same, so it didn't really help. But main thing, he forgets a lot. It's hard for him to memorize and stuff like that.
And I think you talked about to me earlier about trying to help him with homework and some spelling words and things like that when he was a kid. How did he do on those kinds of things?
He's always forget. I mean, he'll get it, yes, and then you ask him the same question, he'll just forget. I mean, right after, thinking that he's already got it, and he forgets. I don't know. I don't know if he gets nervous and he forgets. I don't know. It just, his mind don't work.
Does he appear to have the ability to focus on any specific task at hand?
Not really. He's not really. I don't think so.
Okay.
Getting better now, but back then he just never stayed focused long enough to really learn it, I don't think.
And when you would go to his open houses at school and find out where he was sitting, where was he always told to sit?
Yeah, the teachers always had him up there close to the teachers so he could stay focused. And it's kind of weird because everybody be normal and Bradley be over here on the side by the teacher, but I guess that's a way to keep him focused, I guess.
Okay, but his grades never got better.
No.
Okay. would it be fair to say, in describing Bradley as a child, that he failed to understand any consequences or appreciate the consequences of his actions?
Yeah.
Okay. By that, I think I heard somebody say that he had be corrected or punished for doing something and not realize that he had done something wrong?
Yeah.
Until after he was punished?
Yeah.
Okay.
And
Is that accurate?
Yes.
Okay. And is there anything else that you'd like to tell the court prior to sentencing?
I think he's a real good kid. I mean, he'd get along with everybody. I don't think jail will help him. I think he's at the age now that it's going to be his rest of his life. So I'd like to see him out of jail.
Okay. You do believe some treatment will help him, though, don't you?
Oh, yeah. Oh, yeah.
Okay.
Yeah.
And is he willing to do treatment?
Yeah, I think so.
I don't have any further questions, Judge.
None for Mr. Dunham, thank you, Your Honor. Thank you, sir.
Thank you. Sir, you may step in.
And he's released, Judge.
I'm sorry?
We don't need him to stay, but I mean, he will. We'll turn it over to Mr. Patel for the document.
Mr. Patel, who do you wish to call?
Judge of the defense calls Dr. Randy McDonald.
Clerk, could you swear the witness?
Thank you, Judge. Good afternoon, Dr. McDonald. If you would state your name for the record.
My name is Dr. Randy McDonald.
If you'll give me a moment.
I'm sorry, I can't hardly hear what you're saying.
Never been used to that.
Yes.
Judge, this, would you state, what do you do for a living?
I'm a licensed psychologist here in the state of Florida.
Okay. Judge, by way of stipulation from the state and the defense, we both agree that she is an expert in her field.
Very good.
The state would stipulate.
Very good.
And Judge, by way of stipulation, the state and the defense would submit Dr. McDonald's report and evidence. I believe that was previously provided to you and copied to the state, and it's also on the docket.
Okay. Do we have a copy that we need to go ahead and...
Would you like a hard copy?
I've got a hard copy.
Then I think we're good.
It's all marked up.
Still got one, Judge.
Was it what I said?
Defense.
Was it EFO? No. Your Honor, we had previously reviewed that and had no objection.
Very good.
May I approach?
Court will admit defense to Exhibit A without objection.
Dr. McDonald, have you had an opportunity to meet Bradley Dunham?
I have, yes.
Okay. And tell us how.
Well, initially I was asked to do a consultation with him by his prior defense attorney, Brandy Merrifield. She was interested in determining if he might be a good candidate for a risk assessment. And then that happened in May of 2021. And then I heard about a year later that you, Mr. Patel, had taken the case. And then so we picked up and continued with the evaluation at that time.
At the time Ms. Merrifield was on the case, did the case come in as a juvenile case?
No, I believe it had been direct filed as an adult case.
Okay. And I asked you to do a comprehensive psychosexual evaluation, is that right?
Yes, sir.
How many times did you have the opportunity to meet with Mr. Dunham?
So I met with him in May of 2021, February and March of 2022, So 3 times. Then he also saw a polygraph examiner for a sexual history polygraph exam.
Okay, let's go through this evaluation. So if you would, let's start with what did you evaluate? What are you looking for when you go to evaluate Mr. Dunham?
So I approached these initially as a full psychological evaluation. So I'm trying to determine if there are any neurodevelopmental, psychiatric, neurocognitive issues. So just anything that helps to, understand that person and how they're functioning day to day. When we talk about psychosexual evaluations, obviously we're looking at things like their sexual history, sexual behaviors, sexual interests, all that kind of stuff. And then when we talk about risk assessments, we're trying to determine if they present with any risk factors, whether static or dynamic, as well as protective factors that may mitigate their risk for reoffense in the future. So trying to understand them as much as we can as a person, and then trying to compare them with groups known to reoffend and see if they seem to match those groups. If so, why? If not, why not?
Okay, so let's kind of go through this. Were you able to diagnose Mr. Dunham with a mental health disorder?
So he had been evaluated as a young child. He was 7, I think almost 8 years old. He had been seen by a psychologist, Dr. Nina Golick. She had done an evaluation and offered the diagnosis of attention deficit hyperactivity disorder combined with presentation. So that means that at that time he was demonstrating both inattention and then hyperactive impulsive behaviors. So after spending some time with him and talking with him and going through his history, I conferred or agreed with that diagnosis. I think as he's gotten older, he would probably meet criteria for the predominantly inattentive presentation, but still the condition of ADHD does seem to be there. In clinical interview, when initially asked about mood issues, he denies having any problems with that. But when I gave him testing, objective personality and mood measures, as well as self-report measures, he does endorse some difficulties with things like depression and anxiety and anger. And those are pretty common to folks that have ADHD to also have those comorbid difficulties. I didn't think that he met full criteria for like a major mood disorder, but certainly there's some underpinnings of some mood disturbance that could probably benefit from being addressed therapeutically.
Can you tell us a little bit about the application of medication for your diagnosis? If he's taken it, and then kind of your thoughts on how he should go forward.
At the time I met with him, he was not taking any medications for ADHD. From what I could gather, there had been a very brief trial. I think it was with Ritalin when he was a child. It had sedating effects, and so it was discontinued, and there wasn't really any further follow-up with medication trials. So medication had not been something that was tried very long to treat that condition. In terms of how it might be helpful now, I think it could certainly be helpful with him. During the course of the evaluation, I could see some difficulties with inattention, just in conversation. I would ask questions, and I could tell that he hadn't fully attended to the question, so I was getting a response that wasn't really fitting the question I had asked, and so I'd have to restate it. Sometimes he didn't seem to carry information over from one meeting to another, and again, that's an attentional issue that goes on to affect memory and how we consolidate and can recall information. So I could definitely see some difficulties with inattention ongoing at the time that I met with him. Medications could certainly help with helping him to focus and sustain attention over periods of time.
As far as, can you explain to the court kind of his level of obsessive and compulsive symptoms that you saw and kind of how that applies to the general facts of what he's accused and has pled guilty of?
I didn't notice any obsessive compulsive symptoms. Did I misunderstand your question?
Well, let me rephrase that. Let's talk. Let's do it this way. Did you talk to him about kind of how he was raised and things of that nature before his arrest?
I went through a general, family history with him. He has, always lived with both parents. As was discussed earlier, he has a sister that's much older that hasn't really been in the home during his upbringing. He indicated, something of a conflictual nature of the relationship with his father, but he didn't really, he did not endorse any sort of abuse or trauma or anything of that nature.
Now, at some point he started looking at pornography before he was arrested. How did you reconcile that as it relates to your diagnosis?
Well, I certainly wouldn't say ADHD causes one to look at pornography.
Sorry, would you say that again?
I said I would not say that ADHD causes one to look at pornography. His interest and his sexual interest and all of that seemed to be developed in the way that would normally happen for a young person, so adolescence. And when he was looking at pornography online, it was something that was easily accessible to him. He was interested in looking at materials that depicted persons similar in age to him. So he was 16 at the time. I asked him what ages he was looking for. 15, 16, 17 was the range that he was searching for. And so he was on, it's called Discord. It's an application that people use to have chats with other folks. And he had initially gotten into these groups to talk with other people about gaming. And so that's how it all started. And then, as seems to be common, these groups will sometimes turn to talk of sexual type things and exchanging of files. And so that was how that it began, that he was looking at pornography. People were sharing files with him. He was sharing files with other people.
Do you think that in your conversations that he understood the criminality, so to speak, of his actions?
I don't think that he did, and I say that not just because of what I know of him, but also in having done some of these evaluations with folks of similar ages. They are engaging in something that I think they can say they understand is illegal, but they don't fully appreciate the legal ramifications that they can face if they are arrested and prosecuted for these things. So in his mind, he was looking for material that seemed appropriate for him, and he was not appreciating the fact that having possession of that material was illegal, that and other materials were illegal. And that seems to be a common thread with people that are juveniles that have these kinds of charges. They just don't get it. And it's not surprising, in my opinion, based on the delays that we understand still exist within the human brain at that period of time. So we have these neurodevelopmental processes that we go through, and the brain continues to age into our 20s, age and mature, and so these skills that we need to make good decisions, to appreciate consequences, to understand what can happen, those abilities aren't fully developed when we're teenagers. And then you add on a condition like ADHD, which is a neurodevelopmental delay, and that makes the development of those abilities even slower. So I don't think that he had the brain capacity to fully understand how problematic his behaviors were at that time.
At the time of his arrest, which would be about 16 or 17 years old, how would you estimate that his maturity level was? Of what age?
So, not having seen him at that time, it's very hard to say. Listening to his sister talk about how he, was a bit behind, he always spent his time with persons a year or two younger than him. I would think it's fair to speculate that he was functioning at a social maturity level of someone who was 1 to 2 years younger than he was at that time. So 14, 15, possibly younger. Again, without having known him at that time, it's hard to speculate.
So I want to kind of ask you about, it appears that you saw him quite frequently over February and March of 2022.
Yes, sir.
Would you say that, having spent that time with him at that age, was he functioning at the age that he was?
I would not. And as can be read in my report, when I sat down to conceptualize this whole thing, I didn't conceptualize him as a person that was an 18-year-old person or a young adult. I conceptualized him much more as an adolescent, an older adolescent. At that time, he was in 11th grade. He was a junior in high school. He was living with his parents. He had worked a little bit, but hadn't maintained steady employment. So in terms of his functioning, as we sort of measure functional ability in society, he was below what we might expect of a person who was 18 years old. But even just interacting with him, you see a social immaturity that persisted. And, just in terms of the things he would say, in the report I detail, he misused the term bully and bullying, and that's a function, I think, of a reading disorder that had been indicated, but also just, again, sort of getting focused on terms and misusing them rather than trying to express himself in a more mature and correct way. And even talking about, the offense and all of that, there's a sense of sort of being victimized by it, and just that lack of maturity of the responsibility that he might be more inclined to be taking or understanding that he needs to take at the time.
I want to get to the portion of your report where you talk about risk measures and kind of frankly lack thereof. So if you'll tell the court about some of the risk measures you did in your analysis and why there may be a lack of information.
So risk measures, particularly for persons who have been charged only with possession of child sexual abuse material, are sorely lacking at this point. And the research is still ongoing. At this point, we have one risk measure. It's called the Seaport, and that's for adults, adult males particularly. We don't have anything for juveniles, and from what I can read, and in talking with other people that do these evaluations, we just don't have a big enough sample to study of juveniles who have been convicted of these kinds of crimes and then gone on to reoffend. So we don't have that group of people to study and then analyze and try to come up with factors that make them more likely to reoffend. So now he was an adult at the time I saw him, so I looked at, well, what are my options for adult measures that I can use? Can I use that Seaport? Can I use some of these other things I typically use? And the short answer was no. Because of the nature of the offense, I wasn't able to use a common risk measure, the static 99, looks at static risk factors. The Seaport I couldn't use because he was too young at the time of the offense, even though he was 18 now. And then the dynamic risk factor that I could use was looking at the things that would be more apt to respond to interventions, and it's really normed on folks that have had contact offenses, but the manual does state that we can use it to inform therapeutic planning for persons charged with child pornography offenses. So it wasn't my preferred measure. And that summer I actually went on to do training in a different measure that I now use entirely. I've gotten away from this one. But, you know, I think it broke down nicely the things that we would need to focus on when we're looking at someone and their risk of reoffending, whether sexually or generally.
How old was he when you interviewed him? How old was he?
So the first time I saw him, he was 17, and then when he came back to me, when Mr. Patel was representing him, he was 18 at that time.
So May of 21 is when you first...
Yes, sir.
He was 17, and then February, March of 22, he was 18.
Yes, sir.
Did the results of the polygraph indicate anything to you?
So the polygraph is focused on confirming the sexual history that we get in the course of questionnaires and interviews and all of that. And he passed the polygraph. He was asked specifically about sexual contact with persons who were 4 years or more younger than him. He was asked about ever physically forcing sexual contact on another, and he was asked about any masturbation behaviors in public. He answered no to all of those, and he was found to be truthful in those responses. So the polygraph to me, was indicative of someone who has not engaged in contact offenses and is not engaging in other behaviors of concern.
Were there any issues relating to substance abuse?
No, he had reported having tried, marijuana on one occasion, didn't like it, didn't continue to use it, no use of alcohol, no use of other illicit substances. And to that end, I gave him a measure that picks up on subtle indicators of substance use, and that came back as low probability for substance abuse issues.
About how many cases would you say that you've been involved in to do an analysis relating to possession of child pornography?
I would say probably about 10 at this point. Sometimes I get referred cases and I might go meet with the person and then decide that I don't want to take that case, or I don't think that it's going to be helpful, so I may not see those cases through. But I'm thinking of ones that I have completed the evaluation, submitted a report. I think it's about 10 at this point.
And you wrote in your summary, the statement starts with Bradley's case is unique in that he was a juvenile, and then you go on. Here's what you say. You say Bradley's case was unique in that he was a juvenile, 16 years old at the time of the offense, but charged as an adult at 17. He is now a, in quotes, very young adult at age 18. And then it kind of goes on. Why is this case unique?
Because he was young at the offense. He was 16. He was a minor at the time of the offense. He was a minor at the time he was charged. And then here we are sometime later, at the sentencing phase. So as I pointed out, it was difficult to find measures that I could apply to assessing risk because of his age and the limitations that imposes. And then, I haven't seen a lot of people at this point in my career that have been charged, in this manner. They were minor at the offense and then charged as an adult and sentenced there as an adult.
Okay, so I'm going to ask you this one final question, and bear with me because it may sound a little odd, but here you've got a patient that presents to you as immature, has some developmental disabilities, and tells you that he's interested in pornography at his age and he's trading younger pornography in order to get that. How do you reconcile that?
For me personally, I don't try to reconcile anything. I view my task as trying to understand, and I think that he presented it, pretty clearly, just as you explained. He's like, I'm looking for this one thing, I'm getting this other stuff, and he's putting it back out there, but not considering the consequences of that behavior. So, he was engaging in this behavior that is illegal. I don't deny that. I don't condone the behavior, but I can was doing, and I can understand why he was doing it based on this understanding that he was an adolescent male who is socially immature, who is not thinking about possible consequences of his behavior, and who is, being influenced by these online peers that he has no idea who they are. He doesn't know if they're his age or older or what. He thinks they might be his age, but he's got people that are, in essence, encouraging and modeling the behavior, and he's going along. And again, that's a very adolescent, socially immature thing to do, but it's a common thing, and it gets kids in trouble. And I think that it was a perfect storm of things that were happening at the time that encouraged a really bad behavior.
What kind of treatment options do you think would you recommend based upon your diagnosis?
So I do believe that he would benefit from a psychiatric evaluation to determine whether he would benefit from use of medications to treat ADHD. I think that evaluating person would probably also assess things like depression and anxiety and see if there might be a need for medications to address that. From a therapeutic standpoint, he was seeing a counselor at the time that I met with him early last year. I don't know if that's ongoing. I did request records from that person that I didn't receive, so I'm not sure what the nature of the treatment was or what the focus of it was. But if he was coming to see me for therapy, I would obviously want to focus on, understanding why the behavior was problematic, and then focusing on addressing some of these deficits or weaknesses that I listed out on that final page, just in terms of increasing his social support network outside of the family. Let's get him out meeting people that are his age, that are doing appropriate things, not relying on online persons to be his social support network. I'm sorry. Can the medications and the individual and group therapy, can that be accomplished through the Cordova program in Pensacola? So the program at Cordova Counseling Center that I referenced in the report is a sex offender treatment program, is what they call it. It is once a week. Typically it's group therapy. Now sometimes they will do their initial assessment with people and decide that they would be better individually. I tend to think Bradley would do better on an individual basis rather than putting him in a group that is typical for the group that's there. But it's going to be, treatment that addresses a lot of things in terms of mood issues and interpersonal difficulties, and making sure that sexual needs and intimacy needs and all that are being addressed appropriately, and not making sure that we're developing an understanding of how to manage those kinds of behaviors in a productive way.
He's not yet finished high school, and I understand under this need principle that you put the completion of high school and then job preparedness. Would that be an essential item to get him in a position to grow as a citizen? I think so. I mean, having a high school education seems to be a bare minimum requirement to getting a job these days. I think he would benefit from assistance in looking at what sort of jobs would be appropriate for him moving forward, assessing whether college or vocational training is a good option for him. I think he definitely needs some guidance and direction in those areas, because he has struggled academically, and I don't know that the school is addressing that at this point. Is there any other treatment that you would recommend?
I don't think so. I think counseling, I think a medication evaluation, obviously complying with any medications that are recommended. If the court feels that a sex offender treatment program is appropriate for him, the only option we have at this point is that program at Okaloosa Counseling. I used to work there and I'm familiar with the program. It's a good program. And like I said, if they don't think he would fit into the group over there, they would see him individually. And I think that's probably what would happen, given the difficulties that we've identified here. You know, he might be a good candidate for services offered by the Division of Vocational Rehabilitation. They will do updated assessments and, you know, help him determine what might be a good area of work and employment as well.
I have no further questions, Judge.
Ms. Lawson,
Would you prefer I go up there, Judge?
up to you, but
Good afternoon, Dr. McDonald.
Okay.
I just have a few questions for you, ma'am. I actually want to clarify. The defendant did admit to you that he was actually seeking out child pornography. Isn't that true?
Yes, he admitted he was seeking materials of persons his age.
And that he was actually...
what did you say?
He admitted he was seeking materials depicting persons his age.
And you're also aware, though, ma'am, that he was charged with images that were found in his possession that were as young as 2 and 4 years old, aren't you?
Yes, ma'am.
Okay. So he was actually not just putting those out there, he was actually retaining those images as well. Isn't that true?
He told me he was receiving those images and then had shared a mega link that had an array of images on them.
So he did admit to you that he had a mega account and was sharing those images through mega of child pornography?
Yes.
And he also admitted to you that he knew that he could get more of what he was seeking if they were younger, if he was trading younger images. Isn't that true?
I believe he told me that he knew there were people looking for materials depicting younger people, and so if he came across that, he would put that back out there. And again, the goal was to get materials that he was interested in of persons his age.
And he also admitted to you that he was actually actively inviting others to join at the site or the channel that he was on, didn't he?
Yes, there was sounds like a small group that he was involved in that he had invited to stick with him through the different accounts.
Nothing further, ma'am. Thank you. Thank you, ma'am.
anything else from the defense?
No, Judge.
Thank you, ma'am. Let me step down. Doctor, excuse me. You're excused.
Next, Judge, the defense calls Bradley Dunham.
Madam Clerk, would you swear the witness? Please be seated. Tell your name.
Please state your name, sir.
My name is Bradley Dunham.
And you're here because you entered a plea to what the state accused you of doing, right?
Yes, sir.
You understand that?
Yes.
You understand that no matter what, you're going to become a registered sex offender after today, right?
Yes, sir.
You understand that you'll be put on sex offender probation for a period of time?
Yes, sir.
About how much of your high school have you completed?
I completed around, high school you said? So,
Yeah, high school.
Yeah, I completed almost all my classes. I'm currently working on my 12th grade class online, and I'm almost finished with that. I'm not done.
So when you were arrested, which high school were you going to?
I was going to Choctaw Hatchie High School.
And then at some point, they said you couldn't come back to Choctaw, is that right?
Yes.
Okay, and then where did you end up going to school?
I ended up going online for school. They asked me, well, I had to call them. They asked me to set it up with them, and have all my classes set up. I have to choose my classes, and I don't know how exactly it works, but I have my classes set up and I just started on there.
Okay. And you said you're almost done?
Yes, sir.
When are you supposed to actually finish and graduate high school?
I believe I need to finish my math, my history. What else do I have? I finished my science. I think those are the only two, I think.
And when are you supposed to have those assignments completed by?
I believe within 2 weeks.
Okay, so you're supposed to finish high school in June?
Around there, yes.
Okay. You know, when you got arrested when you were about 16, 17 years old, right?
Yes.
When did you first start looking at pornography?
Well, when I was 16, going on to 17.
So about that time frame?
Yes, sir.
What drove, like, it may sound like a silly question, but what kind of pornography were you interested in?
I was interested into girls my age, sir.
You told me that, kind of like when you were in high school, that friends or other people in school would show like Snapchat videos of other girls in high school.
Yes, it was going through when I'm growing up.
When did you start, well, put it another way, when you started getting online to look at pornography, were you going to like adult sites?
The big ones that were more popular, like Pornhub or Xvideos.
And was that just stuff that you weren't interested in because there were the women or too old or older?
At first, I was fine with it. Going on through those ages, and I got more interested in to figure out what girls my age would look like.
Okay. And you had never been with a girl?
No, sir.
At that time?
No, sir.
Did you ever think about, so you get online, you're looking at girls your age, or wanting to look at girls your age, 16, 17 years old, and that's about, in high school, there's girls that are between 14 and 18, right?
Yes.
Did you think that there was anything wrong with doing that?
I believe it was there, but at the time I wasn't really fully thinking about it until the consequence happened.
And that consequence was getting arrested?
Yes, sir.
Okay, so you told me that, well, tell the court about, like, kind of when you get in trouble, like how you do stuff and then you get in trouble and then you'd realize it was wrong, right?
Yes.
Something like that? So
yes.
Kind of tell the court about, like, growing up and getting in trouble.
Right. As I was growing up as a young boy, I always liked to play. I never really wanted to do schoolwork, as we talked about my grades being bad. But as I was growing up, I wanted to be like the jokester of the class, make everybody laugh. So they would ask me to do these stupid things, and at the time I thought, oh yeah, that's funny, I'll do that. But in the back of my mind, I don't really process, if I do that, then this will happen to me, like get a wrote up or sent home or something like that. Out of all the years of me growing up, especially elementary, had a lot of write-ups for the stupid antics that I've done when I was younger. But again, I didn't really think about it too much until I actually got in trouble.
In this case? Or oh no, then you got in trouble, and then you would realize that what you did was wrong?
Right.
So then, but that would keep repeating itself, right, throughout your adolescence?
Yes.
Do you think that kind of played a role here when you're getting online looking at pornography, child pornography?
As a sense of, from me growing up, I never really had anyone help me or treat me in a sense to say, hey, that's wrong, and these are the reasons why. They gave me like, oh, that's wrong, and then like punish me, and that's it. They didn't tell me why or try to help me figure out why that was wrong, and that's why I always gotten back to getting in trouble, because I didn't get help figuring out why that was wrong.
And I suppose, well, you tell me, but as we sit here today, when you look back and you're 16 or 17 years old, do you think there's anything wrong with looking at 16 or 17-year-olds when you're 16 or 17?
I mean, I know there was only like 2 years ago that...
Hang on just one second, there's a jet flying over. Go ahead.
Yeah, I know that was, again, like 1 or 2 years ago. Oh, wait, I'm sorry, can you...
I'll repeat it.
Give it again.
So, like, as we sit here today, and you think about when you're 16 or 17 years old, and you're wanting to look at girls that age, you presumably now know that it's wrong, but did you realize it kind of around that time?
No. Around the time I was that age, I was thinking, like, oh, it's fine because they're my age group. But again, now that I know that I'm a bit older, having it in general below the age 18 is illegal, and I wasn't thinking about that at the time.
You heard Dr. McDonald talk to you about different treatment options, and you saw her, and medication and things of that effect. Is treatment something that you're interested in?
Yes, I believe it would help me a great deal since, again, I never really fully gone through treatment growing up.
As we sit here today, do you still feel like you struggle with regular tasks?
Yes, for remembering. And I think it's mainly remembering and learning issues from what I have now.
And you still live at home with your parents?
Yes.
Do you see that, well, obviously the judge could make you live somewhere else, but do you see if the judge gave you the opportunity to be on probation, do you see that changing, or do you still feel like you're going to need to be at home a little bit to kind of learn and grow up?
I'm not really sure how that would help me. Growing up with my parents, I always loved them. I always had fun being with them. Being alone, I'm not sure how that will change me or not. Either it could go well, or it could just make me more lonely since I'm not with people I know, like my family.
So you need your family?
Yes.
Okay. That's what I was getting at.
Okay.
And you want to do the treatment?
Yes.
I don't have any further questions.
The state has none for Mr. Dunham. Thank you, Your Honor.
Let me step down. The defense has no further witnesses, Your Honor. Very good. Boston, do you have any witnesses for the state?
No, Your Honor. The court has had the benefit of our sentencing letter and the attached OCSO report. We're asking the court to consider that and would like to present argument when appropriate.
The court has reviewed those documents and will consider them as the court has reviewed the documents provided by the defense. You may make closing arguments.
Thank you, Your Honor.
Shaw.
Thank you, Your Honor. You know, Judge, these are handling cases like this are just so difficult because, in part, what I've learned over the years of handling these is the law really hasn't caught up with technology. And what I mean is that at our age, even at Mr. Patel's age, it's hard to understand how cases like this can come up. But when we look at it in the context of the technology that's out there, what these children, young people are getting bombarded with every day, and realized this was a 16 to 17-year-old boy, minor, and that's chronologically. I mean, the evidence here today is that he was operating on a lower level by up to 2 years. He was also suffering from a mental defect, and as I mentioned, immature. And that's why we generally have juvenile court handle cases like this. The law recognizes that children, minor defendants are not fully developed in their brains, in their thinking, in their ability to understand the consequences of their actions. That's why the law recognizes that. But we're here today in adult court, and Bradley Dunham's being treated just like a fully mature adult who clearly should have been able to, an adult would have been able to understand the consequences of his actions. Judge, we believe the evidence that you heard today establishes a basis for each of the downward departures that we outlined in our opening. At the outset, I'd point out that Mr. Dunham will be designated, as you heard earlier, as a sexual offender, with all of the attendant issues that causes for finding work, places to live, places he can go, access to different things on the computer, and that kind of thing. So that's going to be done. 2L, Judge, we're requesting the court to find that Mr. Dunham should be sentenced as a youthful offender. The evidence established that Mr. Dunham was 16 to 17 years old chronologically when these offenses occurred, but the evidence established that he was operating on a much lower level. We'd ask the court to withhold adjudication of guilt and sentence Mr. Dunham to 6 years of probation, including the sex offender probation and the designation, as we mentioned earlier. Secondly, Judge, 921.026-2K, the evidence established that, again, Mr. Dunham was a minor at the time of the offenses. The testimony from the stand was he was less mature than his chronological age, has ADHD, did poorly in school, was held back in the 3rd grade, and still was not successful at that time. And lastly, 921.00262D, the testimony of Dr. McDonald established that Mr. Dunham requires specialized treatment for a mental disorder which is unrelated to substance abuse or addiction or for a physical disability. Mr. Dunham himself testified that he's amenable to treatment, and that treatment will be very helpful to Mr. Dunham, and he wants to do it. We would also point out, Judge, that to the court that the PSI that was prepared by probation and filed with the court, has an optional recommendation, Judge, and that recommendation indicated that, and let me just read it to you. It should be noted, however, that the defendant was a juvenile at the time of these offenses. If the court thinks this defendant lacked sufficient maturity at the time of the offenses to fully comprehend the seriousness of his actions and these offenses, then the court may want to consider a long period of supervision with a suspended prison sentence. We believe that recommendation, Judge, if you don't feel comfortable with the 6 years provided under the youthful offender, this alternate recommendation would be appropriate. This option gives the court a long period of supervision while recognizing Mr. Dunham's age, immaturity, mental disorder, and amenability to treatment. Judge, we're just asking you not to treat this young man, this juvenile at the time of the offenses, like a fully developed, fully formed, fully mature adult, and recognize that there are problems with Mr. Dunham, as testified by Dr. McDonald, with regard to his maturity and with regard to his medical and mental diagnoses. We're asking the court to find that the mitigating factors are not only proven, but the court should find either or all of them and sentence Mr. Dunham as requested. Thank you, Judge.
State wish to make a closing.
Yes, please, Your Honor. Your Honor, Dr. McDonald mentioned that she hasn't seen many juveniles in adult court for the possession of child pornography, and there's a reason for that. There's a reason that Mr. Dunham is before this court, and the state is asking the court to treat him as an adult. The defense talks about how, as a juvenile, juveniles are bombarded with things on the internet, things that are bad for them, that may lead them astray. Your Honor, Mr. Dunham is part of that problem. He is one of those that was bombarding others with images of children being sexually abused, very young children. He was the one putting it out there. He was actively trading child pornography. He even had a mega account that he was sharing the link with others so that they could access even more files containing images of children being sexually abused. He was inviting others to join the group that he was in, the channel as they referred to it in Dr. McDonald's testimony. He is part of the problem. His actions are actively causing children to be victimized over and over again. That is why he is here in adult court, Your Honor, based on the decisions that he made, the actions that he took. The key is that he did offend, he did commit those criminal acts, and we're asking the courts to hold him accountable for the hundreds of children that he has assisted in being victimized by his actions. He even admitted, Your Honor, that by having and seeking out those that were very young and trading those that he would get more of what he wanted. And much has been made of what he supposedly was looking for, things children of his own age, 15, 16 years old. But Your Honor, if you refer to the charging document, please look at what he was charged with. He's charged with 2-year-olds, 4-year-olds, 5-year-olds, 6-year-olds, 7-year-olds. We only go as high there as 11, 12, and 13. We don't even get up to the 15-year-olds. What he had was the young children. That's what he showed an interest in. That's what he was trading. And that's what concerns us, Your Honor. That's what we're asking the court to hold him accountable for. He was only charged with 20 counts of possession of child pornography, 4 counts of transmitting the child pornography to others over time, and 1 count of unlawful use of a two-way device, which makes him eligible for minimum guidelines of 95 months in Department of Corrections up to 125 years. As the court is aware, the state is seeking 10 years in Department of Corrections, followed by 10 years sex offender probation with the required designation and GPS, et cetera, as I mentioned in my recommendation. Part of the reason, Your Honor, is because he went so far as to seek out the pornography, to trade it, to store it, to give it to others. If you look also in the police report, it also talks some more about some of the sexual acts that were depicted. And as the court is well aware, they are very graphic. I'm not going to go into those because the court has the benefit of those. But this is what Mr. Dunham was looking at. This is what Mr. Dunham was sharing. And that concerns us. It is an interest in very young children. Regardless of what he says, this is what he had. And this is what he was doing. The defense, Your Honor, has asked the court to treat Mr. Dunham as a youthful offender. The state does not dispute that he is eligible under the statute, but we do believe that it is not appropriate given the nature of his actions. It only gives the court a 6-year window of supervision. The state's position is we need much more. We need eyes on this individual for much longer because of the danger that he presents. And the state believes that nothing less than the minimum guidelines for the Department of Corrections is appropriate. that certainly not that 6-year window with a minimum of 4 years of Department of Corrections is appropriate. So while we agree that he is eligible, we do not believe it is appropriate, and we ask the court not to treat him as a youthful offender based on the totality of his actions, the fact that he was trading, possessing, and actively getting others to do so. The defense has also asked for a downward departure based upon the fact that he's been diagnosed with a mental disorder for which he requires specialized treatment and for that which he is amenable to. As the court is aware, before the court can downward depart, that there must first be a legal basis, and that second, that it is appropriate. The state does not believe that the defense established the legal basis of the mental health disorder that requires specialized treatment. The only testimony that the state actually heard, and that we believe was presented in the report and by Dr. McDonald, is a diagnosis of attention hyperdeficit disorder. There was no other diagnosis. She even said he had no mood disorders. Now, while he could get benefit with some treatment for socialization, for getting out there, those are not mental health disorders. So we do not believe that if that qualifies as a mental health diagnosis for which he requires specialized treatment. As the court is well aware, ADHD is pretty mainstream. That is not a specialized treatment, nor did Dr. McDonald indicate that for the ADHD that is diagnosed that he requires any type of specialized treatment. So we do believe that the defense has not met their burden on that particular basis for a downward departure. The other downward departure grounds that they're asking the court to consider is that he was too young to appreciate the nature of his actions. Your Honor, the defendant chose to make decisions. He knew to look for child pornography. He knew that if there was younger, it was better. I can trade it for more. He made decisions that would change children's lives forever. We're asking the court to hold him accountable for the decisions that he made. He was not too young to appreciate the nature of his actions. He actively engaged in this conduct, and he knew that if I go younger, it's better. He knew what he was doing. We're asking the court to hold him accountable. Your Honor, even if the court believes that the defense has met their burden and established a legal basis for a downward departure, the state does not believe, based on the totality of his actions, that it is appropriate to do so. And we're asking the court to, as I stated, to adjudicate him, to sentence him 10 years Department of Corrections plus 10 years sex offender probation, to designate him as a sexual offender as required by law, to complete the treatment for sex offenders, provide the DNA samples, that he not have any unsupervised contact with minors at any time that he were to be under any supervision, that if he were placed on supervision, that in accordance with the statute and the Jessica Lunsford Act, that he be on a GPS monitor, and that he not have any electronic devices capable of internet access or social media access. We're asking for a forfeiture of all seized devices, and I believe the court costs are $867, but I'm not sure. I'll leave that to Madam Clerk. Your Honor, there was a reason based on the totality of the charges and what Mr. Dunham possessed and the actions that he took, that he's here before this court as an adult. The state is asking the court to hold him accountable as adult and to sentence him as requested. Thank you, Your Honor.
Mr. Shaw.
Just briefly, Judge, I'd like to address and correct something Ms. Basso said. She said that his interest was in the youngest of the children. There's no evidence of that. The undisputed evidence was that he was seeking out age-appropriate images. And also, I'd like to point out, Ms. Basso, I guess saying ADHD is not in need of specialized treatment. Depression is mainstream as well, but it requires some pretty dang specialized treatment. How young would the state agree is too young to ask for prison time for a child? Because the state's argument completely conflicts with 921-0026 that in at least two different places recognizes youthful offender and then the age is too young to appreciate the consequences of their actions. Ms. Basso overlooks that Mr. Dunham was a child himself who suffered from a mental disorder who will benefit and is amenable to treatment, Judge. So again, we'd ask the court to find that the defendant and the defense has met the burden of proving the mitigating factors apply and should be utilized. Mr. Patel would like to be heard on the Jessica Lunsford issue, Judge.
And Judge, I don't think that the Jessica Lunsford, the GPS monitor requirement is a requirement under the Jessica Lunsford Act. I know the state is steadfast in maintaining that the court has no choice. They would be citing to 94830 sub 3, which states that effective for a probationer or community controlee whose crime was committed on or after September 1, 2005, and who, A, is placed on probation or community control for the violation of Chapter 794, Section 800, 04, sub 4, sub 5, or sub 6, and 827.071, and Section 847.0145, and has unlawful sexual activity involved with a victim, the age is 15 age or younger, and the offender is 18 years of age or older. I do not believe that, well, frankly, if the statute wanted, or if the legislature wanted the crime that Mr. Dunham has pled to require it, they would have put it in here. But there's this added element of the fact that that unlawful sexual activity with a victim under 15 and the offender over 18 is also a requirement. And what does that tell us? That essentially tells us that there is such thing as hands-on offense and hands-off offense. I don't believe that the Jessica Lunsford Act at this stage is appropriate. However, if he was to violate probation, then there's another statute that says that it is. And as such, we don't believe that a GPS requirement is required per statute. Thank you, Judge.
Governor, may I be heard briefly on just that one point, or I can sit down?
I don't need to hear anything right now. I'll deal with it in a second. Okay, I'm going to take a short break. Come back and make one.
All right, please.
South of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
At Powell, Powell & we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning. So come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m. serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning. So come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties.
All rise, please. The circuit court is back in session.
Should the defendant stand at the podium? First of all, the court needs to make rulings with regards to the downward departure. And the court finds that the criteria in 2D that the defense did not make, did not prove their case with regards to the diagnosis and specialized treatment. However, the defense did meet the criteria for 2K, dealing with the youth of the defendant as well as the youthful offender. However, this is a two-step process, as the defense, as the state has referenced. It's not only whether the requirements or the statutory requirements are met, or whether, based on the totality of the circumstances, whether there should be a downward departure. And the court finds that there, all things considered, there should not be a downward departure. But the court keeps coming down to, while this is a younger offender than many that we deal with in these circumstances, and when there are difficult cases like this, the court has to rely on the law and assume that the law contains with it a summary of the values of our society. And the reason why the law deals with these type of cases and possession cases so strongly is because of the tremendous damage that is done by them. And even today, you may or may not fully appreciate, Mr. Dunham, but the court does appreciate, based upon, unfortunately, the years of having to deal with abuse of young children, that when each of these young victims that are contained in these videos, each of them have not had a traumatic event, but have had a destroyed childhood. The child will never be the same. And that's what's confronted by this, and that's why it takes such a harsh stand in order to try to discourage not only the possession, but even more so the propagation, the spreading of these types of images. So, based upon that, the court is going to sentence you to the statutory minimum, not the statutory, the guideline minimum of 95.85 months in the state prison, followed by 10 years of sex offender probation, and the following statutory requirements, obviously sex offender treatment, DNA samples, comply with registration requirements, no unsupervised contact with any minors, $867 in court costs, and forfeiture of all seized devices. Probation following incarceration will be sex offender probation, no internet access or use of devices capable of internet access, and $50 per month cost of supervision. There will be an adjudication of guilt on these. You will get credit for time served. With regards to the issue regarding the GPS monitoring required in the Jessica Lunsford Act, the court's going to reserve on that. I'm going to give you guys kind of pulled that one. I was unaware of this was up here, so I want to make sure that I make a good proper ruling and give the state the opportunity to review not only the statute but the case law, both of you, not them, but to give both of you the opportunity to do this. The court's going to reserve as to the GPS monitoring that the state has requested under the Jessica Lunsford Act or for any other reason. But the question of GPS monitoring will be reserved. Obviously, you've got a few years in order to deal with that, but if you'll maybe give that to me in the next, 15, 30 days? What do you need?
30 days.
30 days, that's fine. And then the court will make a ruling. If you'll give me, we may have to reconvene just to make a pronouncement or something like that.
And Your Honor, while the court has imposed sex offender conditions, but the court, I don't believe, has announced specifically a designation as a sex offender?
Correct. Court is so designated. So it's 95.85. Now, the other portion. So we need these are the total sentences. This total sentence Do we need to split them up between counts?
Yes, Your Honor, to get a legal sentence, we'll need to split those out.
What would you suggest, and I'll give the defense this.
Your Honor, we would suggest on, I want to go to the charging document to make sure we're on the right years on these. They're both third degrees. Okay. Your Honor, then we would suggest on count 1 would be 60 months Department of Corrections.
Did you say 60?
Yes, sir.
Okay.
60 months Department of Corrections. And then on count 2 would be 35.85 months Department of Corrections consecutive to count 1. And then on count 3, Your Honor, we would suggest 5 years or 60 months sex offender probation to be served consecutive to both counts 1 and 2. And then on count 4 would be also 60 months or 5 years sex offender probation to be served consecutive to counts 1, 2, and 3. And then we would recommend, Your Honor, that the remaining counts 5 through 25 be 5 years or 60 months sex offender probation to be served conserved concurrent to count 4. I believe that then gives us the 10 years of sex offender probation and the 95.85 months. Yes, sir.
Defense have any particular?
That appears appropriate.
Open. I mean, it doesn't. As long as without objection, the court will so order to make sure that it's a legal sentence. Okay. Anything further that we need to address here today?
Not from the state, Your Honor. Thank you.
No, Your Honor.
That's good.
Your Honor, I got Malik Coward in 22 CF 438. If I may approach.
You may. Ms. Dudley, if I had known you were going to give me a plea here and not argue, I would have let you go in front of that.
I've been working outside going over the plea when they started, Judge.
All right. I just didn't realize. Just make sure and communicate that. And everyone's time and value. Go ahead. Would you please announce the plea?
Yes, sir. Your Honor, count 2, the state's going to dismiss. And count 1, the defendant's going to enter a plea to the lesser included misdemeanor, carrying a concealed weapon. And then count, I guess I wrote that wrong. It should be count 3. I need to amend that. And the count 3 will be amended charge of possession of paraphernalia. Adjudication of guilt, 270 in court costs. 1129 probation per count consecutive. Substance abuse evaluation and recommended treatment. No weapons or firearms, maintain employment, or attend school full-time. The evaluation will need to be done within 30 days, and any treatment to begin within 60 days. Probation may convert to administrative probation after the first year if all requirements are complete, and he will be supervised by JCS.
Is that the agreement with the state?
That is the agreement.
Just do me one favor. Put that count 2 and scribble over the top of it and put count 3, number 3. Count 3. That's great. Yeah. Perfect. Thank you. Okay. You handed me. Did you hand me a score sheet?
It's 2 misdemeanors, Your Honor.
Yeah, it's misdemeanors, Your Honor.
Oh, I'm sorry.
It's 2 misdemeanors.
Okay. Very
Same
good.
score sheet.
Okay. Mr. Cowell, would you please raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so I heard your attorney state the terms of your plea agreement, and I'm looking at the written plea and sentencing agreement that you've signed, and it says the same thing. Have you read this sentence recommendation? It's really an agreement.
Yes,
Have you read this closely? And have you gone over it with your attorney? Make sure you had all your legal questions answered?
Yes, sir.
You understand that by entering this plea, this will be a final resolution of this case, but you're waiving some valuable legal rights to get here. The legal rights are the right to go to trial, right to have a state prove their case. All those are valuable legal rights. You believe it's in your best interest to do that?
Yes, sir.
And nobody threatened or coerced you to get you to enter into this plea?
No, sir.
And you had all your legal questions answered?
Yes, sir.
Okay. Satisfied with your legal representation?
Yes, sir.
Very good. Based upon that, the court will accept your plea agreement, and pursuant to the agreement, the state will be null processing or dismissing count 2. As to count 1, pleading to a lesser included carrying of a concealed weapon, and then the amended charge of possession of paraphernalia. You'll have be sentenced to 11 months, 29 days probation for each count. They'll run consecutive. That means they're on top of one, so it's a total of 2 years, basically, okay? Got the substance abuse evaluation and recommendation in 30 and 60 days, and then it can convert to administrative probation, etc. You're supervised by JCS. And you have all the court costs as required. And there will be an adjudication of guilt on these 2 counts.
Yes, sir.
Anything else?
No, sir.
Okay, any questions?
No, sir.
Thank you.
And I'll advise them to report to JCS in the morning. I will give them the contact information.
Your Honor, did we announce that he's supervised by JCS just to make sure probation?
I did.
Yes, sir.
Okay,
And Your Honor, I'm going to release Deputy Stinson, Deputy Stinson from the courtroom.
Sorry to keep you all waiting. Are you stepping out, Taylor?
I know. I was just going to. Your Honor, that's all I have. May I be excused?
I gave you all this time. You guys didn't work this one out too?
Well, got to have a client, Your Honor. I got to have my client is not here. This is Steve Medina for Keeley M. Annon, A-N-N-O-N, on the 230 docket in 22 CF 2733. I've been looking for all afternoon and have not seen her and don't have any information. For the court's awareness is that the 2 phone numbers that I had, I've been trying to reach her for really weeks now and haven't been successful. So I was really dependent on her showing up today. We have a very reasonable, actually a couple of options for her to resolve this case for a misdemeanor, either with some misdemeanor probation or some jail time. So unfortunately, she's not here.
Well, perhaps when she gets picked up on the capias we're going to issue, if she's in jail, you might have sufficient time to be able to sit down and talk to her. So the court's issuing no bond capias.
Thank you.
Maybe you can hopefully keep it open and figure out what's happening when she gets taken into custody.
Yes, Your Honor. Thank you.
Okay, thank you. I think that's a wrap.
Your Honor, before you leave the bench, I do have a score sheet. If I can approach, that was from earlier. Mr.